Hi, I'm Carlos Perez, a member of Choate and Stewart's Intellectual Property Litigation Group.
And I'm Christine Savage, the chair of the healthcare practice here at Choate.
Today we'd like to talk a little bit about information privacy and data security. As more and more of people's lives is recorded in computers and on computer systems, as we use those systems to interact, tons and tons of data is being generated about our activities, about our businesses, even about our health and our children. And as a result of all that, the government and regulatory bodies, legislatures, even businesses themselves have paid more and more attention to how that data should be secured and how it should be protected from unauthorized access.
We've represented many clients confronting data losses, and we've found in our experience that they need to address 4 critical questions immediately in order to be able to respond appropriately. First, they need to determine what happened, and that involves determining what happened both from a technology perspective as well as a human element or error issue. Second, they need to consider what risks are involved, and that depends largely upon the types of data that are involved, whether it's health information, social security numbers, or financial information. The third question that people need to address quickly is who do we tell and when do we tell them? And Carlos, there are 3 different categories of people that sort of are in that who do we tell category, sort of the must tell, the should tell, and the want to tell. Can you talk a little bit about some of the who we must tell?
So the must tells are driven, literally by the law or the regulations that apply. So depending on the kind of, again, this is how it's all driven by the facts on the ground. Depending on the kind of data that you have that you think may have been exposed inappropriately, then you'll have different regulatory schemes. For instance, if you've got healthcare data, there's one set of regulations and one set of sort of notification requirements. If you've got financial information, there's another, and then there's sort of an overlay, which is in some states like Massachusetts, there's particular regulations that apply to sort of a cross-section of just kind of general identity information, social security numbers coupled with names, coupled with other information. So who you have to tell is going to be driven by literally the regulatory or the legislative scheme. And unfortunately, in the United States, that is a mesh of schemes from across all 50 states in a lot of cases, because each state may have a different requirement or different set of requirements. So it really is an issue of figuring out what's the data set that may have been lost, what's in there, what kind of people, where are the people that it covers, and then coming to sort of the lowest common denominator of who you have to notify and how you have to notify them. And when you begin to deal with all those constituency, that really brings you to the sort of the 4th question you always got to deal with, which is how do you manage the aftermath or the longer term effects of a loss or a breach?
So there's a number of things that you need to keep in mind after the breach has occurred and after you've started to make some of those regulatory disclosures. First is, do you have insurance coverage that's available, and are you satisfying all of the requirements in order to keep that coverage viable in terms of handling the matter going forward? Second, you need to consider whether or not there are third-party indemnifications or contracts if a third party was involved in the breach itself. Is there someone else who can be helping to absorb some of the costs associated with remedying the breach or compensating those who may have been harmed as a result of the breach?
And finally, there's managing the risk of litigation going forward. We've seen a serious uptick in the plaintiff's bar filing quickly putative class action suits when one of these breaches becomes public, and making sure that you're prepared to deal with that and prepared to deal with both the issues of whether the class should be certified, and if it is, how that litigation should be managed is an important piece.
To summarize, there are 4 key considerations that need to be kept in mind. First, what happened? Second, what are the risks and how do we keep this from happening again? Third, who do we tell and when do we tell them? And fourth, how do we deal with the aftermath?
So obviously we hope that you never have to deal with these issues, but if you do, for all these reasons, it's important for you to keep in close contact and work closely with your legal team.